is it not now clear that the British authorities knew that the United States were using torture techniques against Binyam Mohammed? Will the Foreign Secretary now tell the House what steps the British government took at the time to deplore that use of torture? Will the Foreign Secretary now tell the House what steps the British government took to ensure Britain was not complicit with that torture at the time? Will the Foreign Secretary guarantee today that at no stage in this case was Britain in breach of either our domestic or international obligations on torture? Mr. Speaker, anyone who has followed this case closely, including evidence given by the Security Service officer involved to the courts, will recognise that knowledge of the American use of torture did not remain within the Secret Service, but was almost certainly passed on to the highest levels of government. So will he now tell the House, if he knows, whether ministers were told that the US were torturing Binyam Mohammed and when? And will he now ensure that all such evidence is given to the police in charge of investigating allegations of British complicity in torture in the Binyam Mohammed case? Mr. Speaker, I accept totally that the Foreign Secretary fought this case for honourable and just reasons. But will he now take another honourable step, given this and other allegations of British complicity in torture, and set up a wide-ranging judicial inquiry?
Foreign Secretary.
Mr. Speaker, while I'm glad that the honourable gentleman says that he welcomes the work that is done by the security forces and intelligence services and salutes their work, I honestly believe he does himself no justice by first asking questions which he knows for reasons of legal circumstance I cannot answer, nor for repeating as questions allegations which he knows the answer to. Let me go through them. He asked about the case that involves the so-called witness B. He knows that I cannot talk about that case because it is currently being in front of the courts. And I think that it is not right to seek answers to questions that would prejudice or could prejudice an ongoing police investigation. Equally, he asked whether or not the police have been given access to all the relevant papers, and he knows very well that all the relevant papers have been handed over to the police, because that's the basis on which the Attorney General made her decision to ask for a police investigation. Now, he also asked what will be the effects, I think was the word that he used, of this case, and how will it be seen through. I think on that, Mr. Speaker, it depends on how the debate is carried forward, but he will know from the successive reports of the Intelligence and Security Committee that significant changes have been made in the nature of the guidance that is issued to our Security Intelligence Service personnel. Significant changes have been made in the way that policy is promulgated. And individual cases, as well as the generic issue, have been examined, have been set out by the Intelligence and Security Committee, and their recommendations have been followed, and the government has said very clearly what it has done in those respects. There is one outstanding issue which concerns the publication of the current guidance, the reformed guidance in the light of the Binyam Mohammed case, that is currently sitting with the Intelligence and Security Committee, as the Prime Minister promised the House it would before publication.
Diane Abbott.
Is the Foreign Secretary aware that many people listening to this debate this afternoon will be surprised to hear the Foreign Secretary describe this court ruling as a vindication, whereas in fact he's been forced to reveal information that he's struggled for a very long time not to do, even when the information was legally available in the United States? And is the Foreign Secretary aware that to describe the information released today as completely clearing the government of any involvement, past or present, in extraordinary rendition and thus complicity in torture, that cannot be right. And he must be aware, whatever is happening now under a new American administration, there are still questions to answer about past British involvement and in extraordinary rendition and thus in torture.
Well, Mr. Speaker, the vindication is of the control principle, and that is made very clear by the court. Secondly, the court makes clear that in the absence of the American judgment of December 2009, it would have found in favour of the government. And that is a very important point. Thirdly, in respect of extraordinary rendition, and I don't recognise her description of UK complicity in extraordinary rendition. The questions have been asked about extraordinary rendition in respect of Diego Garcia. She knows, I think very well, my honourable friend knows very well, that 2 cases have emerged from American studies of their files. They were immediately publicised to this House in the appropriate way, and there have been subsequent questions, but also subsequent answers to each and every one of those questions in respect of Diego Garcia. And I think it's very important that we don't allow the impression to go abroad that there are outstanding issues in that respect when there are not.
Mr. David Davis.
Thank you, Mr. Speaker. Can I thank the Foreign Secretary for making this statement today? I think it's very good that he's doing that. Just before he stood up earlier, The Guardian published on its website a copy of a letter from Jonathan Sumption QC, his lawyer, and raising the matter that the government are still seeking a redaction, it would appear, from the judge's rulings. And this is a very long letter, but I'll just read him a very short extract and ask him to comment on it. This is: the Master Rolls observations are likely to receive more public attention than any other part of the judgment. They will be read as statements by the court that the security service does not, in fact, operate a culture that respects human rights, that officials of the service deliberately misled the Intelligence and Security Committee on this point, that this reflects a culture of suppression in its dealings with the committee, the Foreign Secretary and indirectly the court, which penetrates the service to such a degree as to undermine any UK government assurances based on the service's information and advice, and that the service has an interest in suppressing information which is shared by the Foreign Office for which he is responsible. Could he comment on those?
Well, Mr. Speaker, I will comment on it, but it's very, very important that the facts are on the record, not the allegations. And I hope you'll allow me to go through this. First of all, it's not correct to say that the government, or actually more specifically the counsel for the government, sought redactions of the judgment. A redaction suggests that there was an item which we wanted to see deleted, but which we accepted was true. What our counsel did was to provide, once he'd been provided with a copy of the judgment in draft, as is normal practice, there was real concern that one paragraph set out conclusions that went beyond the evidence presented, and raised, as well as raising prejudice in respect of the ongoing case in respect of witness B. Our counsel took the view that that should be brought to the attention of the judges in the case. The 3 judges addressed that letter, and they decided then to amend the paragraph so that it took the final form that it did. The court concluded that the concern was well-founded, and so it revised its paragraph in the light of that. Now, I think it is very, very important that we also remember that in open court today, the counsel for Mr. Mohammed has apologised unreservedly for releasing this private legal document, which is a normal part of legal practice that it should take place. I also think it's very important that there is no suggestion anywhere to impugn the integrity of the judiciary in making their own judgments. What the judiciary say in a draft judgment or in a final judgment is their business, and their independence is at the heart of their final words. And the words that appear today in public are the words of the justices in the case, and it's their decision to put them out on that basis.
David Winnick.
Is my right honourable friend aware, and I in no way question his integrity, that for some of us, the heart of this issue is simply this: did security officials, British security officials, know that torture was being applied against Mr. Mohammed by the US? And if, in fact, no action was taken by us, and no information given to ministers, I consider that to be a stain on the reputation of our country. It should never happen again. It's not simply good enough, Mr. Speaker, to say that Britain is not a party to torture. If, in fact, we know that torture is being carried out by our closest ally, we have a responsibility to act. And I'm afraid that in the case of Mr. Mohammed, we didn't do so.
Mr. Speaker, my right honourable friend is absolutely right. That we do not just have responsibilities in respect